Hi, my name is Pearl, and today we're going to talk about 100% guaranteed way to recover your money from the fraud builders. We have prepared this video after discussing with former High Court judge. Therefore, if you're seriously interested in recovering your money from the fraud builders, you should watch this video attentively and repeatedly. Here is our strategy, which has 4 main points. First, you should lodge a large number of criminal, RERA and consumer cases, where the builder and the other accused persons would be made to realize that either they repay your money or they and their conniving near and dear ones would be arrested, whose bail will strongly be opposed and who would have to spend rest of their lives in jail, and all their known, unknown and benami assets would be traced and confiscated. Secondly, we don't expect the directors of the builder company to repay your funds. With utmost humility, I repeat that we do not expect the directors of the builder company to repay your funds. Therefore, you should ensure that all their known and benami properties are traced and confiscated, and that they should get life term in jail. However, your focus should be to recover your money not from the builder directors, but from the marketing companies, their directors, their sales agents, who are now cash rich and who had deceitfully induced you to invest in the proposed project of the fraud builder, and from the banks and housing finance companies that had financed the bogus project of the builder without proper pre-sanction appraisal, without ensuring proper end use of the funds lent. Thirdly, in all total 8 cases should be lodged. 1 as FIR under sections 409, 120B of IPC, not with EOW, but at your local police station. Please note that the addition of section 409 in FIR is very necessary because it carries sentence of life imprisonment. Second case as a complaint case. In criminal court under section 200 of the CRPC. Third case for money laundering with the Enforcement Directorate and 2 cases in RERA. 1 against the builder and another against the marketing company. Additionally, 3 separate cases should be lodged in Consumer Commission. 1 against the builder, 2nd against the real estate marketing company, and the 3rd against the banks and other housing finance companies. Depending upon the nature of the case, the following persons should be made accused or respondents. Firstly, the builder company, its directors, auditors, and top managers. Secondly, the marketing company, its directors, and its sales agents. Thirdly, the banks and other housing finance companies that had offered to finance the purchase of flats, and lastly, the other willful beneficiaries of the embezzled money. Fourth point of our strategy is that the anticipatory as well as the regular bail of the accused persons in criminal cases must be strongly opposed at all levels till the time your money is repaid with interest. If any of the accused persons is able to get bail from lower courts, the same must be immediately challenged in superior court and should be got stayed and cancelled. Please note, Honorable Supreme Court does not allow bail to builders where large number of investors have been duped. Now, I shall explain a few other important considerations. You should yourself trace balance sheets, names and addresses of shareholders and directors of all the group companies promoted by the builder. You should trace the large number of beneficiaries who may or may not have been made directors in scores of companies created by the builder for concealing the investors' funds and for money laundering, and you must get them arrested. You at your own level must also ensure that known, unknown, benami properties created out of the misappropriated funds of the investors are traced and attached. So far as your complaint is concerned, you must, I respectfully repeat, that you must write in the end of your complaint that you had entrusted your money to the builder for the construction of the flat for you, but the directors of the builder company, in connivance with different banks and in connivance with the auditors, in connivance with the builders, sales agents of the marketing company, and various other top managers, diverted and siphoned off your money for the personal use, and you have not been given the possession of the flat so far, though they were supposed to have given the possession long back. That the above allegations constitute offences under 409 and 120B of IPC, and that your complaint should be registered as FIR. You should also state that the police should arrange forensic audit of the accounts of the builder, and that the properties of all the directors and of other accused persons created out of the embezzled money must also be traced and attached through court orders. I very humbly would like to reiterate that you must mention Section 409 IPC in your complaint. Mentioning in the FIR of Section 409 is very essential because the offence under Section 409 is punishable with life imprisonment, and in cases where Section 409 is attracted, the Court of Magistrate has no jurisdiction to grant the bail. If you are not careful on this point, the police, as a matter of routine, will register your FIR under Section 406, which is punishable with imprisonment up to 3 years only, and your police case gets weakened. When a builder defaults, naturally large number of investors feel aggrieved, and many of such investors make complaint to the police. In this type of matters, police usually registers one complaint of one investor as FIR and cites other complainants as witnesses. Such an action of the police of registering single FIR relating to one project of the fraud builder is very beneficial to the accused, but destroys the interest of the hundreds or thousands of victims whose complaint is added to the charge sheet and who, instead of being the main complainants, are cited as just witnesses only. So, it is of paramount importance that not only yours but complaints of all the victims are registered as separate FIRs. Honorable Delhi High Court has also held in recent division bench judgment that every complaint of cheating or of criminal breach of trust against a builder is to be registered as a separate FIR. When hundreds of thousands of FIRs are registered, against the builder and his co-conspirators, who will then have to face trial in hundreds of thousands of cases in a large number of different courts all over India. It will be practically impossible for these accused persons to get bail in each case, because some courts will never grant bail to such accused persons who have duped hundreds and thousands of investors, and these accused persons will never be able to come out of jail. At the time of arguments, on the point of sentence, you should request the court that the builder and his co-conspirators must be awarded consecutive sentences in different charges and in different cases. That is, sentence for different charges and in different cases should run one after the other, like in Lalu Yadav cases. At this stage, you must also impress upon the court that heavy amount of fine or compensation equal to your investment must also be awarded, and that the sentence of at least 1 year imprisonment in default of payment of fine should be ordered. Such default sentences, as per law, run consecutively. Hence, in this example, the fraud builder and his near and dear ones in 100 cases would have to spend at least 100 years in jail and shall die in jail. If you want, we shall send you copies of latest Supreme Court judgment on consecutive running of sentences. Same way, if these 100 investors had instituted 100 separate cases in Consumer Commission, and there also just 1 year sentence is awarded in each case, which is ordered to run consecutively, then all these accused persons shall have to remain in jail for another 100 years. Relating to the consumer cases, in this way, the fraud builders and other conspirators shall either repay the investors or they will never be able to come out of jail and they shall die in jail. The essence of this strategy can be summed up in one sentence. Every investor should ensure that he should make cases not only against the builder but also against the marketing company and also against the banks, etc., and also against the other willful beneficiaries, and must see to it that his complaint to the police is registered as a separate FIR at his local police station under sections 409 and 120B of IPC, and that he should institute separate consumer cases, and that bail of the accused persons should be strongly opposed till Supreme Court level. And at the appropriate stage, the court should be requested to award consecutive sentences and heavy amounts of compensation or fine. And of course, there must be obsessive follow-up. With great humility and with utmost regard, I reiterate that if you follow this strategy, the fraud builders and other conspirators shall either repay your money or they will never be able to come out of jail, and they shall die in jail. I would also like to remind you that our judicial system is excellent, but it is very slow and extremely costly. Therefore, you should have patience and must do obsessive follow-up. Making a complaint to the police, or for that matter, making a complaint anywhere and forgetting about the same, is not going to get your money back. Remember, follow-up, and obsessive follow-up is the mantra for success for recovery of your money with interest. If you are busy and you cannot do this much of running about yourself, then you must appoint some well-educated, sincere and bold representative having good public relations skills and good knowledge of police, court and jail proceedings to do this obsessive follow-up on your behalf. I very respectfully would like to remind you that the courts are impressed by arguments and not by slogan shouting crowds. If you are a member of some investor forum, you may continue to remain a member of that forum. But if the investors seriously want refund of their money, then each investor should have his own separate police case, separate consumer case, and a separate lawyer. What I have stated so far is legally 100% correct. Yet, this is neither a legal advice nor it is intended to be a legal advice. Over and above what I have stated so far, the most important point is that you also need to have the fighting spirit. It is a matter of great shame that the dishonest builders, marketing agents and their sales agents are enjoying five-star lifestyle with your money, and the poor investors, after payment of monthly installments of bogus bank loans, are struggling hard to pay school fees of their children. You must do your level best to recover your money with the attitude of whatever it takes. Legally, of course. We are a debt recovery agency and we have special expertise in debt recovery from notorious builders through legal means. If you want us to recover your money from the fraud builders, or for that matter, from anyone else, please send us a WhatsApp message on the phone number 9810396571 or email us at sarthibbs@gmail.com. Our policy is no recovery, no charges. Our charges are very reasonable, and that too you will pay us only after receipt of your refund. Of course, initially you will incur a little expenses to file 8 cases. All information about your dealings with us shall be kept strictly confidential. So, please feel free to communicate with us. We shall shortly be publishing similar informative videos on guaranteed ways to recover your money from builders. All these videos would contain a wealth of information and will be very helpful to you for recovering your money from the builders. You must watch all such free videos and share these videos with other victims. Please press the subscribe and bell icon so that you should immediately get the notification of our new videos. Thank you very much. Vande Mataram.